Civil procedure, pleadings. The complaint, the answer, motions, and other pleadings. Many courts today maintain case documents in electronic form. Pleadings, motions, and petitions can generally be filed with the court over the Internet today. Federal Rule 11 provides for sanctions against the attorney or client for harassment, frivolous arguments, or a lack of factual investigation. All pleadings provided to the court must be signed by the attorney or the client representing herself. The signature certifies that the purpose is not improper. There's some legal basis for the claims, and the facts or denials are supported by evidence. An accusation of a Rule 11 violation can be made by the opposing party or by the court. Following the accusation, the attorney in question has 21 days to rectify the matter or respond. After the 21-day period, the violation will be filed with the court. Potential sanctions include fines, dismissal of claims, or dismissal of the entire case. The purpose of the sanctions is to deter future violations, rather than punish past behavior. The filing of the complaint by the plaintiff commences the lawsuit. The following three elements must be included in the complaint. Firstly, a statement showing how the court has jurisdiction over the subject matter. A state matter is dealt with in state court, and a federal question should be addressed in federal court. Secondly, a short and plain statement of the claim showing how the plaintiff is entitled to relief. Thirdly, a demand for judgment. The plaintiff must request a remedy from the court. As notice pleading is the doctrine in the federal court, the complaint need only provide a short and plain statement of their cause of action. The idea is that a plaintiff and the attorney, who have a reasonable but not perfect case, can file a complaint first, put the other side on notice of the lawsuit, and then strengthen their case by compelling the defendant to produce evidence during the discovery phase. There are exceptions where details or specificity is required in the complaint. Claims for special. These are unusual or unexpected damages. Claims for fraud and mistake must be entered with substance, details and specifics. Once the complaint has been served, together with the summons, the defendant has 20 days to do one of two things: file an answer or respond with one or more motions against the complaint. In response to the complaint, the defendant can request a court order to amend the complaint or dismiss the case. If the complaint is too vague or insufficient, the defendant can file a motion for a more definitive statement. A motion to strike requests the court to have the plaintiff remove insufficient, redundant, immaterial, impertinent, or scandalous allegations. Some motions to dismiss the case must be provided in the first response, either the answer or a motion responding to the complaint. Otherwise they are deemed waived by the defendant and cannot be raised later on. These include motions to dismiss on grounds of lack of personal jurisdiction, improper venue, insufficiency of process, and insufficiency of service of process. Motions of failure to state the claim on which relief may be granted, and failure to join an indispensable party can be made at any time during the trial. Lack of subject matter jurisdiction is more fundamental, and a motion challenging subject matter jurisdiction can be made even after the trial has concluded. The answer is a formal pleading where the defendant sets forth the response to the complaint. The defendant must answer the complaint. Unless the defendant responded with a motion, the answer must be provided within 20 days of service of process. If the response was via motion, the defendant has 10 days from the denial of the motion to provide the answer. As well as avoiding the costs associated with service, another incentive to waive service is that it buys the defendant more time. Following waiver of service, the defendant has 60 days to answer. In responding to the allegations, the defendant can either admit, deny, or plead insufficient information. A pleading of insufficient information is available only when the defendant does not have information available, either in her possession or in the public domain. If the information is available via an online search, pleading insufficient information is not an option. There are some important things for defendants to remember when filing the answer. What is not denied is deemed to have been admitted. And if an affirmative defense is not raised in the answer, it's deemed waived for the whole case. So the defendant must deny allegations she does not want to admit. A general denial denies everything in the complaint. This is not often seen, as usually at least some of the facts alleged in the complaint are true. These points are so important they're worth repeating. If you fail to deny the answer, you're deemed to have admitted the allegation. If you fail to raise affirmative defenses, such as the statute of limitations, laches, license, statute of frauds in the answer, these defenses are forever waived. They cannot be raised later in the case. The U.S. courts do not allow mistakes or omissions in the pleadings to obstruct the course of justice. Broad scope is allowed for parties to amend their pleadings. Both parties have a right to amend pleadings once before the response is provided from the other side. If this is a pleading with no response available, the right to amend once continues for 20 days from the submission of the original. If the 20-day window is missed, this is not usually an issue, as amendment is provided by leave of court. The court will freely allow amendments when justice so requires. The court will generally allow amendments unless there's been undue delay, and to allow amendments will prejudice the other party. Sometimes the evidence submitted in court does not correspond with what was pled in the pre-trial papers. A new claim may be asserted by a witness against one of the parties in court that was not anticipated or written up in the pre-trial pleadings. If the issue is not pled pre-trial, the opposing party can object to its admittance in court. But if they do not object, and the evidence is admitted, the pleading can be amended at any time to incorporate the new evidence and claims. The request can be made to the court to amend the pleadings at any time, before, during, even after trial. Failure to amend does not affect the result of the trial. Again, the courts do not allow mistakes or omissions in the pleadings to obstruct the course of justice. A new claim added to the case after the statute of limitations has run is not barred if the initial claims were filed with the statute within the statute of limitations period. The new claim is said to relate back to the original claims and effectively take advantage of the initial claim priority date. New claims are attached to old claims and relate back if they're part of the same transaction and are permitted by law.